In April 2026, before the Vermont Supreme Court, self-represented appellant Kevin Blay challenged a lower court ruling in a dispute with the town of Burke, located in Caledonia County, Vermont. The case centered on allegations that town officials failed to properly comply with requests made under Vermont's Public Records Act, 1 VSA, sections 315 to 320, a law designed to ensure government transparency by giving citizens the right to inspect public records. Blay argued that public records were repeatedly denied or withheld, while the town maintained that the requested documents had been produced and that required administrative appeal procedures were never followed. After the Superior Court granted summary judgment in favor of the town, the dispute advanced to Vermont's highest court, where transparency, access to public records, and the limits of government accountability came under scrutiny.
Good morning, Your Honors. The matter before the court this morning is the case entitled Kevin Blay v. Town of Burke. Appellant Kevin Blay is self-represented. Representing the appellee, Town of Burke, is attorney Sarah Buxton.
Okay, thank you very much. Good morning again. Mr. Blay, can you hear me, sir?
Yes, Your Honor. Your Honor, there is a delay in the transcription, so if you'll bear with me and be patient with me, I'd appreciate it.
Oh, sure. We'll be, that'll be fine. And we can hear you just fine. So as soon as you're ready, please proceed.
Thank you, Your Honor. Good morning, honorable members of the Vermont Supreme Court. My name is Kevin Blay, and I come before you on appeal of Superior Court Caledonia Unit Docket 24 CV 04448, where the court honored a motion for summary judgment on behalf of the town of Burke and denied a motion for the appellate to reply. The case is very simple. I advanced a request to inspect public records on September 20th and 21st, 2024, and made additional inquiries about those same requests on September 26th, September 30th, and October 7th, 24. The September 20th, September 30th, and October 7th denials to the inspection of those records were all audio-video recorded. The audio, video, and supporting transcript of the October 7th are part of the court record and serve as the foundation of my complaint. And please note, all of my requests remain unfulfilled to this date. My request and repeated attempts to inspect those records are not challenged, nor is the town's failure to clarify, failure to extend the time allowed, failure to respond in writing, and failure to notify of the appeal process, or even the failure to certify that some records may be exempt from inspection. In an effort to advance my interest in inspecting those very public records that were repeatedly denied, I had to educate myself on when, where, hows, and whys of doing it. I found all of that in a publication entitled A Matter of Public Record, A Guide to Vermont Public Records Law by James C. Kondo, Secretary of State, circa 2014. Cited by the lower court and appellee's attorney as a decades-old guidance document that does not bind the town or the court. This guide is not just kabuki poetry, but rather a guide that is deeply rooted in law, citing all Public Records Act laws as well as many case laws, all while spelling out the procedures and timeline that would allow a self-represented individual like myself to advance an appropriate appeal on what Secretary Kondo's referred to as the most important of all of the Vermont laws, the foundation to which all others are built on. The same guide is the very first reference in today's Secretary of State's webpage on the PRA. Ironically, Secretary Kondo's acknowledges and credits attorney Paul Gillies, presumably one of the founding partners in the appellee's law firm, for all of his contributions making this guide possible. It is nothing short of incredible that the town claims to have never denied a request, despite more than a dozen flat-out verbal denials on the September 20th, September 30th, and October 7th recordings. The appellee's brief even acknowledges how a denial can occur by failing to respond in writing within the prescribed time. The appellee even acknowledged that I, the appellant, orally requested to inspect the records that remained unfulfilled again on October 7th, and the appellant was informed that, quote unquote, none of this is available right now, and when I get that figured out with the attorney, you'll get what you get. That's page 6, paragraph 1 of appellee's brief. At that point, the still outstanding records related to salaries, total income, and benefits of each town employee were more than 2 weeks past due and already deemed denied by the expiration of time of 3 days. And these very records remain unfulfilled. Town also argues that I failed to appeal the denial administratively to James Sullivan. The Secretary of State's guide is not silent on this issue. It clearly states the denial must be in writing. The writing must include a statement about your appeal rights. The appeal is taken to the head of the agency. And in the case of an elective town clerk, which is there is no one in a superior position, so the decision of the clerk is final, justifying the right to appeal to the Superior Court of your county. Notwithstanding the guidance of the Secretary of State, Mr. Sullivan is not the head of the agency, nor has he ever been identified as such. In closing, now comes the appellant who prays that this court recognize my rights to inspect the very records that have been intentionally withheld for more than a year and a half, and prays for whatever other relief the court deems appropriate. I yield back.
Okay, thank you very much. We'll turn to counsel for the appellee. Please start by introducing yourself and your client and then proceed.
Thank you. Good morning, Mr. Chief Justice, and may it please the court. My name is Sarah Buxton of Tarrant, Gillis, and Shems, representing the appellee, the town of Burke. The town respectfully asks that this court affirm the lower court's decision because the undisputed material facts show that the town never denied the appellant's records request and that the appellant failed to comply with the administrative appeal requirements of the Public Records Act. The appellant has raised a number of complaints and grievances against the town throughout the case and again today. He has failed, however, to bring forth any evidence, including citations to the record, affidavits, or any other admissible evidence as required by Rule 56C2 that raise a genuine dispute about any material fact that the town has asserted. Without this, the town's statement of facts remains the undisputed record for the purposes of deciding summary judgment. And so, as the facts show, the town never denied the appellant's request for public records. Instead, the record shows that the town actively produced the requested records within the required timeframes. It provided Mr. Blaze with responsive documents via email on at least 4 occasions, and provided copies of the records and opportunities for Mr. Blaze to come and inspect the records during multiple in-person visits to the town office. The facts also show that during Mr. Blaze's October 7th visit, the town clerk answered questions, provided referrals to appropriate contacts, and made on-the-spot photocopies. Later that same day, her office emailed the remaining records related to his salary and benefit records request, though he never responded to that email. If Mr. Blaze genuinely believed that the town's production of records was insufficient or incomplete, the statute required him to give the town an opportunity to cure his perceived deficiency by filing an administrative appeal, and he chose not to do this. Under the Public Records Act and this court's clear precedent in Bain v. Windham County Sheriff, any denial of a public records request must be appealed to the head of the agency before a complaint is filed. Mr. Blaze admits that he bypassed this step, arguing that he was justified to do so because there is no head of the agency in the town of Burke. But the record shows that the town had adopted a public records policy that expressly designates the town administrator as the appellate authority for carrying out the requirements of the Public Records Act. It also shows that Mr. Blaze was provided with a copy of this exact policy and that he'd actually used this appeal process in a separate matter prior to filing this suit. Again, in this case, he chose not to do that. The enforcement and administrative requirements of the Public Records Act are designed to foster transparency and cooperative dialogue, not to serve as a trap for municipal officials actively working to fulfill requests. Based on these and other undisputed material facts in the record, the town asks that the court affirm the Superior Court's grant of summary judgment. Thank you, Your Honors. The town will now rest on its brief, though I'm happy to answer any questions that you may have.
Okay, thank you. I don't see any hands, so thank you very much. How much time does the appellant have left?
Appellant has 54 seconds remaining.
Mr. Blaze, did you hear that, sir?
Yes, Your Honor.
Please go ahead.
I have to challenge everything that Kelly has said. I provided actual audio and video of all of the denials. They're uncontrovertible. And additionally, as I stated, under 1 VSA 315-5 Bravo, any person making a request to an agency for records under subsection A of that section shall be deemed to have exhausted the person's administrative remedies with respect to each request if the agency fails to comply with the applicable time limit. As I stated, they failed to do that repeatedly. You can't simply allow holder of the records to just deny them simply by ignoring them, which is exactly what's going on. I still don't have the records that I've requested to this very day.
Okay. All right, thank you very much. Please now call a conclusion.
Unfortunately, the publicly available hearing ended before the Vermont Supreme Court announced its decision. To determine the outcome, we reviewed the court's written opinion issued after oral arguments. In the end, the justices sided with the town of Burke, concluding that the evidence showed officials had responded to Kevin Blay's requests, provided access to records, and later supplied the remaining salary and benefit information by email. The court found that Blay failed to present sufficient evidence to establish that his requests had actually been denied, leaving no genuine dispute of material fact for trial. With that finding, the Supreme Court affirmed the lower court's judgment, bringing the public records dispute to a close. The decision serves as a reminder that in civil litigation, allegations alone are rarely enough. Courts ultimately decide cases based on the evidence preserved in the record. Do you think the court reached the correct conclusion, or should the dispute have been allowed to proceed to a full trial?